Welcome to the deep dive. This is where we take source material you provide and, well, we dive deep, pulling out the key insights for you.
Think of it as getting you up to speed quickly, maybe with a few surprising details along the way.
Exactly. Today, we're looking at a document called Why Subsection 8 is Not a Cap. It's from Legalized Negligence and Advocacy of One, and it's dated June 11th, 2025.
That's the one. And it zeroes in on a specific legal argument, doesn't it? All about Florida statute section 768.21 negate.
Right. The big question the document tackles is, should we call this statute a cap on damages, or is that term actually, well, wrong?
And not just wrong, but according to the source, potentially harmful to the very cause of people trying to change this law. It's quite a strong stance.
So our mission here is to really get clear on the legal distinction the source is making. We need to understand why they think this difference in wording is so incredibly important.
Because it's not just about grammar, is it?
Not at all. In law, in policy debates, getting the language precise. It can make or break an argument, affect real causes you might care about.
Absolutely. The source insists that getting this wrong isn't just a technical mistake. It actually misrepresents the whole legal and constitutional fight needed to challenge it.
Okay, let's roll up our sleeves then. What does this document tell us about Florida statute section 68.218A? What's the background?
Well, according to this source, the statute comes into play in wrongful death cases involving medical malpractice in Florida.
Okay, medical malpractice, wrongful death. Got it.
And it specifically involves what are called non-economic damages.
So things like pain and suffering, loss of companionship, that
Yeah.
sort of thing, not the medical bills.
Exactly, that's the category.
And the source kicks off by noting that some advocates, perhaps for impact, call this statute a 100% cap on non-economic damages.
Yes, and they acknowledge, look, that phrase is rhetorically potent. It's catchy, right? It sounds dramatic.
100% cap definitely grabs your attention.
But the source pushes back hard. They label that phrasing legally inaccurate, a serious distortion even.
They even say it probably wouldn't fly in court if someone tried to describe the law that way.
That's their assessment. They argue that using this 100% cap language isn't just a slip of the tongue. They feel it risks confusing the real issue when talking to legislators or judges.
And maybe even hurting the repeal effort itself.
That's their key concern. They believe it harms the cause by fundamentally misstating what the law actually does.
Okay, so if it's not a cap, according to this document, what is it? How do they describe what FS 768.218 really does?
They're quite precise. The source says the statute prohibits certain people entirely from recovering these non-economic damages in these specific cases.
Prohibits entirely. Who are we talking about?
The document gives examples like parents whose adult child dies due to med mal, or adult children whose unmarried parent dies. Specific family relationships.
So wait, it's not putting a limit on how much money they could possibly get. It's saying they get zero non-economic damages.
That's exactly what the source argues. It denies the right altogether for these groups to recover those specific damages.
Denial of the right.
Yeah, the legal term they use is denial of standing, meaning these particular people are flat out barred from even presenting their claim for non-economic damages to a jury.
Wow.
The source's bottom line on this is pretty stark. For these individuals, under the current law, no cause of action exists for those non-economic damages.
That feels fundamentally different from a cap. Like, completely different. It's not about limiting the award. It's about being shut out.
That is precisely the distinction the source document is built around. They dedicate a significant part of it to breaking down the difference between a legal cap and what they call this statute an exclusion.
Okay, let's unpack that comparison. How does the source define a typical cap versus this exclusion?
Right. So a cap, they explain, is generally understood as a ceiling. It puts a limit on the amount of damages you can recover. It's about, how much money.
A maximum payout. Makes sense.
But the exclusion, which is how they characterize section 68.212, that prevents recovery at all. It's not about the amount. It's about whether certain people can recover that type of damage, period.
So the impact on the actual person, the plaintiff, is dramatically different then, based on this analysis.
Oh, completely. The source points out that with a typical cap, your claim usually still goes forward. You get to court, you argue your case, maybe a jury awards damages.
But then the judge might have to reduce that award because of the statutory cap.
Exactly. The process plays out, but the final number might be limited.
Okay. But with this exclusion in section 768.218,
according to the source, the claim for those non-economic damages by those specific people, it's barred entirely. No recovery allowed. Why? Because the right to bring that specific claim just doesn't exist for them under the law.
That just changes the whole landscape of the legal fight, doesn't it? Does the jury even get involved if it's an exclusion?
That's a key point the source makes. With a standard cap, the jury hears the case, assesses the damages, even if the final judgment gets adjusted.
Right.
But with the exclusion under Section 768.218, for these specific plaintiffs and these specific damages, the source says the jury is never permitted to even hear about it. They don't get to present that aspect of their loss.
So, legally speaking, these must be two very different beasts.
Fundamentally different, argues the source. They describe a cap as a substantive limitation on the remedy. It limits the relief you can get.
Okay.
But they frame the exclusion in Section 768.218 as something much deeper, a procedural or substantive elimination of the right itself. It takes away the ability to even make the claim.
And this difference, the source argues, even changes the constitutional arguments you might bring.
Yes, absolutely. They suggest that challenges to caps often focus on things like equal protection regarding compensation amounts or maybe fairness of the limit itself.
Right. Is the limit too low? Is it arbitrary?
Exactly. But exclusions like Section 768.218, according to the source, raise more fundamental constitutional questions. Things like access to courts, due process, equal protection based on who is excluded, and just basic fairness.
So it shifts from arguing about how much is fair compensation to arguing about whether you're allowed to seek compensation at all. It's a completely different level of question.
Okay, this is really clarifying the source's position. They state point blank that calling Section 768.21 HOSTAP is wrong because it conflates two very different legal structures.
And they're clearly passionate about this. They really hammer the point that a cap implies the right to recover is there. It just gets limited in the dollar amount. But Subsection 8, in their view, isn't a limit. It's a complete prohibition. It stops certain people from recovering non-economic damages based purely on their family relationship in these specific med-mal death cases. It's about standing, not quantity.
And they insist this isn't just some academic debunk for lawyers. It has, and I'm quoting here, profound consequence for both legislative strategy and constitutional analysis.
Precisely their point. Because as they frame it, arguing about a cap leads to debates about money. How much is too much? How do we balance victim compensation with, say, insurance costs or healthcare affordability? Okay, a debate about limits.
But arguing about an exclusion, that forces a different debate entirely. It becomes about who gets excluded from seeking justice. Are we okay with saying certain family members simply aren't allowed to have their loss recognized by the courts in this way?
That is a fundamentally different moral and legal conversation.
It really is.
And the source even gives examples of how advocates could reframe this, right, to counter the cap language.
Yeah, they offer a couple of suggestions. One is pretty direct, calling Subsection 8 a 100% cap on non-economic damages may be catchy, but it's legally misleading.
Go on.
A cap implies the right to recover is intact, but limited. Subsection 8 denies the right entirely. This isn't the limit, it's a legal void.
A legal void. That's striking language. What's the other suggestion?
Even more blunt, perhaps. A cap tells the jury how high. Subsection 8 tells the family, don't bother showing up.
Wow. That really crystallizes the difference they're talking about, the complete denial of access for these specific people regarding these damages.
It certainly gets to the heart of their argument. This isn't about money limits. It's about the basic right to even make your case.
So if we were to boil down the source's final message here for advocates, for legislators, what is it?
I think the core message is this. The fight to repeal Section 68.218 isn't really about lifting a cap. According to the source, it's about restoring the right to be heard for people who are currently shut out.
And using the 100% cap language, however catchy.
They believe it sacrifices legal accuracy and potentially undermines the very legal and legislative arguments needed for success. They want lawmakers especially to grasp that this statute eliminates the claim for certain groups, not just puts a ceiling on potential damages.
Okay, so this deep dive into why Subsection 8 is not a cap has really highlighted, based on the source's argument, this vital difference between a legal cap limiting the amount and what they call a legal exclusion, like Section 768.218, denying the right to recover entirely for specific groups.
And it's a stark reminder, isn't it, how crucial precise legal language is. It's not just for lawyers in courtrooms. It affects how all of us, how you listening, understand these complex policy fights, especially when, strong rhetoric might actually cloud the legal reality.
Definitely. So just reflecting on the argument presented in this source document, here's something to think about. According to Legalized Negligence, an advocacy of one, The central debate around changing Florida Statute 768.218 isn't really about dollar amounts at all. It's about something more fundamental: who's even allowed to walk through the courthouse door to seek justice for their loss.